intervention or.
That's what a lot of people don't seem to understand, you know.
I was not working in the courthouse. He was in the Pasadena courthouse in California with small courthouse with 10 other Court of Appeals judges in that courthouse. I, of course, was working in Washington, D.C.
When you did see and talk with Judge Kaczynski, what type of things did you talk about?
We were among the 12 co-authors of the Brian Garner-led book on judicial precedent. So for several years, that was a project. All of us were, the 12 of us, I guess it was in total, were working on that. Diane Wood, Chief Judge of the Seventh Circuit, and,
right.
And Justice Gorsuch was also a co-author, so we worked on that as a group. And then Justice Kennedy, for the last 30 years, had Judge Kaczynski run Justice Kennedy's law clerk hiring process, and in the course of that process, I would have communications with the judge.
Okay. Did you know anything about these allegations?
Nothing.
Okay. Before they became public last year?
No. When they became public, the first thought I had was no woman should be subjected to sexual harassment in the workplace, ever, including in the judiciary, especially in the judiciary. And when I heard, when they became public, I think it was in December, it was a gut punch. It was a gut punch for me.
It was for me, too.
It was a gut punch for the judiciary. And I was shocked and disappointed, angry, swirl of emotions. No woman should be subjected to sexual harassment in the workplace. And I applaud Chief Justice Roberts' appointed committee of judges to establish better procedures. Chief Justice Garland did the same thing for our court. And those are first steps. I don't think they're final steps by any stretch. And this is part of a much larger national problem of abuse and harassment. And one of the things we've learned is we need better reporting mechanisms. Women, in particular in the workplace, need to know if they're the victim of harassment, where to report it immediately, who to report it to. They need to be know that they'll be safe if they report it. They need to have a safe working environment and be safe if they report it. They won't be retaliated against, and they'll be protected if they report it. And that's part of the steps, or one of the steps that's, I think, being improved as a result of the working group or committee that the Chief Justice has appointed. And I'm interested in doing everything I can to assist those efforts to make those workplaces safe. Again, it's part of a broader national problem, whether it's priests or teachers or coaches or doctors or business people or news people. There's a broad national problem that needs to be addressed, including in the judiciary, and
okay.
I applaud Chief Justice Roberts for doing so.
Okay, I'd like to talk to you now about the Chevron doctrine. Now, this is an important judicial doctrine that takes its name from the Supreme Court case that created it back in the 1980s. In that case, the Supreme Court instructed federal courts to defer an agency's interpretation of the law if the law is, quote, ambiguous, unquote. Some of your academic writings express skepticism about the Chevron doctrine and concern that it allows an administration to impose its policy preference by avoiding the political process. I can understand why this would be appealing to an administration, but I also think it's a threat to the separation of powers because it transfers power from Congress and the judiciary to the executive branch. That's why I've introduced the Separation of Powers Restoration Act to reverse the Chevron doctrine. Many members of this committee have co-sponsored this legislation. And as someone who has written extensively about the separation of powers, can you tell us why the separation of powers is so important and how how it helps to protect individual freedom.
The separation of powers protects individual liberty because it responds to the concern the framers had, that something Senator Klobuchar said yesterday from Federalist 47, that the accumulation of all power in one body would be the very definition of tyranny. So Federalist 47 talks about that, Federalist 69. So the separation of powers, to begin with, protects individual liberty. It does so because Congress can pass the laws, but you can't enforce the laws. A separate body has to decide to enforce the laws. And then even if the law is enforced, and a citizen may say, well, I want someone who didn't pass the law or enforce it to decide whether I violated the law or whether the law is constitutional. And that's why we have an independent judiciary to guarantee, as an independent matter, our rights and liberties. And the three branches, therefore, do separate things because it all tilts toward liberty. It's hard to pass a law, as you know, in the Congress. And then, even if it does get passed and affects your liberty, a separate body has to decide, usually U.S. Attorney's Office, to enforce the law, and that's a separate decision. That helps protect your liberty. And then even if that happens, you go to a court and you say, either I didn't violate that law, as I'm accused of doing, or that law is unconstitutional, or they're interpreting that law in a way that's not consistent with what the law said. The court independently decides that. It's not the members of Congress or the executive deciding that. That's how the Constitution's separation of powers tilts toward liberty in all its respects. Now, as to your specific question, Senator, one of the things I've seen in my experience in the executive branch and in the judicial branch is a natural tendency, but it's a natural tendency that judges need to be aware of and then respond to. So here's the natural tendency. Congress passes laws, but then can't update the law. So maybe it's an environmental law, or maybe it's some kind of law dealing with national security. Let's take those two examples to illustrate. And then an executive branch agency wants to do some new policy and proposes a new policy to Congress, but Congress doesn't pass the new policy. What often happens, or too often I've seen, is that the executive branch then relies on the old law as a source of authority to do this new thing. And they try to say, well, the old law is ambiguous, so we can fit this new policy into the old law as justification for doing this new thing. And I've seen this in national security cases. I've seen it in environmental cases. You see it all over the place. It's a natural phenomenon because the executive branch wants to implement what it thinks is good policy. Now, when those cases come to court, it's our job to figure out whether the executive branch has acted within the authority given to it by Congress. Have you given them the authority? And my administrative law jurisprudence is rooted in respect for Congress. Have you passed the law to give the authority? I've heard it said that I'm a skeptic of regulation. I am not a skeptic of regulation at all. I'm a skeptic of unauthorized regulation, of illegal regulation, of regulation that's outside the bounds of what the laws passed by Congress have said. And that is what is at the root of our administrative law jurisprudence.
Okay, one of the most important qualities I look for in a judicial nominee is the ability to impartially interpret the law and apply it to the case before the court. Now, this can often be the most difficult part of a judge's job because it may require the judge to rule against a litigant that may be sympathetic or against a policy that the judge may personally agree with. As Justice Sotomayor's confirmation hearings, Senator Schumer commended her for, quote, hewing carefully to the text of statutes, even when doing so results in rulings that go against so-called sympathetic litigants, unquote. Do you believe that it's important for a judge to interpret and apply the laws that Congress has actually passed, rather than seeking to make up or change the law if the judge doesn't like what the Congress has done? And if so, why or why not?
I agree completely, Senator. That's at the foundation of what I view as the proper judicial philosophy.
Okay.
The separation of powers system you described, we have to stick to the laws passed by Congress. You make the policy. We'll follow the policy direction that you put into the laws that are enacted, passed by the House and Senate, signed by the President. We don't rewrite those laws. The executive branch also shouldn't be rewriting those laws beyond the scope of the authority granted.
Okay, some of my colleagues have criticized you for purportedly ruling too often against environmental interests. It seems to me that many of these circumstances boil down to the fact that some of my colleagues don't like the environmental laws Congress has actually passed and are frustrated that they haven't been able to get their own preferred environmental policies signed into law. Now, I've looked through your record, and I found that you have not hesitated at all to uphold environmental regulations when they were actually authorized by statute. Could you give us a few examples of cases where you have upheld environmental regulations because you concluded that Congress had authorized them?
Limited to as many few as you can as time has run out.
Senator, as I said yesterday, I'm a pro-law judge, and in environmental cases, in some cases I've ruled against environmentalist interests, and in many cases I've ruled for environmentalist interests. And they're big cases, cases like the American Trucking Association's case, where I upheld a California regulation for a majority over a dissent, stricter air quality standards in the National Association of Manufacturers case, EPA rules for particulate matter in the UARG case, permit process applicable to surface coal mining in the National Mining Association case, the Murray Energy case rejecting a premature challenge to a Clean Power Plan regulation, the National Resources Defense Council case versus EPA, ruling for environmentalist groups. In a case that was a big money case where the industry wanted an affirmative defense to be created for accidental emissions. The affirmative defense was not in the statutes passed by Congress. The industry came in with their lawyers and said, well, just write the affirmative defense into the law. And I wrote the opinion saying, no, it's not in the law. And yes, that might be a problem for industry, but we follow the law regardless. And so there are a large number of cases where I've ruled in favor of environmentalist interests because that's what the law required in that case.
Well, thank you, Judge. I appreciate it.
Thank you, Senator.
Senator Leahy.
Well, thank you, Mr. Chairman, and good morning, Judge.
Thank you, Senator.
You and your family. We have a lot of questions, and I know you've done a lot of preparation with a couple of our distinguished Republican colleagues about the questions you might be asked. But let me ask you something that normally isn't an issue during Supreme Court hearings. You testified before this committee in both 2004 and 2006 as part of your nomination to the D.C. Circuit Court. Then you were nice enough to come by my office and chat with me last month. I asked you that if you changed anything in your prior testimony, and you said no. Is that still your position?
It is, Senator. I told the truth. I was not read into the programs.
No, I'm not asking about what we did. I just asked you if you would change anything in your...
Well, I'd like to explain if I can.
I'm going to give you a chance because I'm going to ask you a couple of questions. Go ahead.
Well, I just wanted to explain that at the last hearing in 2006 in particular, you were concerned, understandably, because there had been two judicial nominees who had been involved in the legal memos, in the legal discussions around crafting the enhanced interrogation techniques and detention policies. You were concerned whether I also was involved in those. And I made clear in response to those questions that I was not read into that program. That was 100% accurate, still accurate today. I think Senator Feinstein's report and the Office of Professional Responsibility report established that I was not involved in those programs. Now, there were two judicial nominees.
Okay, I'm going to go into that in a little bit. I don't want to go over my time as the preceding senator did. I want to stay with.
Well, Senator, I just want to be clear. I want to reassure you.
I'm going to go into it. I'm going to give you a chance to speak a lot more.
Without
but let me.
Hey, I'm not going to take time away from you, but I want to explain something. I said yesterday that if a question is asked within the 30 minutes, that he can finish the question and it can be answered. So he did not go over his time.
So I didn't mean to hit a sensitive area. Let me ask you this: between 2001, I'm new here. Between 2001 and 2003, 2 Republican staffers on this committee regularly hacked into the private computer files of 6 Democratic senators, including mine. These Republican staffers stole 4,670 files, and they used them to assist in getting President Bush's most controversial judicial nominees confirmed. Now, the theft by these Republican staffers became public in late 2003 when the Wall Street Journal happened to print some of the stolen materials. The ringleader behind this massive theft was a Republican staffer named Manny Miranda, who had worked for one of the members of this committee. In a way, it was considered by many, both Republicans and Democrats, as a digital Watergate, not a theft not unlike what the Russians did in hacking of the DNC. Now, during all this, you worked hand in hand in the White House with Manny Miranda to advance these same nominees where he was stealing material. Not surprisingly, you were asked extensively about your knowledge of this theft during both your 2004 2006 hearings. And I don't use the word extensively lightly. You were asked over 100 questions from 6 senators, both Republicans and Democrats. And you testified repeatedly that you never received any stolen materials. You knew nothing about it until it was public. You testified that if you had suspected anything untoward, you would have reported it to the White House counsel, who would have raised it with Senator Hatch, especially as Mr. Miranda had worked for him. And at the time, we left it there. We didn't know any better. Today, with the very limited amount of your White House record that has been provided to this committee, and it is limited, for the first time, we've been able to learn about your relationship with Mr. Miranda and your knowledge of these events. So my question is this: did Mr. Miranda ever provide you with highly specific information regarding what I or other Democratic senators were planning on asking certain judicial nominees?
Senator, well, let me contextualize, because I'm looking at what you're putting up here first. In the renewed.
Thank you.
Well, the question.
So that what's up there is 100% accurate. That's my memory.
Okay, so let me ask you this. That's
never knew or suspected. True. Never suspected anything untoward. True. Had I suspected something untoward, I would have talked to Judge Gonzalez.
And I've already
would have talked to Senator Hatch. That's all 100% true.
And that's what I had already said. But did Mr. Miranda ever provide you with highly specific information regarding what I or other Democratic senators are planning in the future to ask certain judicial nominees?
Well, one of the things we would do as a White House is on judicial nominations, and I'm coming to your answer, but I want to explain, is to meet up here, and this happens on both sides all the time, with teams up here about, okay, their judicial nominations, our judicial nominees are coming up. How are we going to get them through? Here's a hearing coming up. And during those meetings, of course, it would be discussed, well, I think here's what Senator Leahy's going to be interested in. That's very common. I'm sure in President Obama's administration, when they had similar meetings, they would probably have meetings and say, well, I think this is what Senator Graham will be interested in. That's what you do in meetings with. So highly specific would, I think, I'm not sure what you're getting at by highly specific.
I've been here over 40 years. I know what both Republican and Democratic administration do in preparing. I'm not asking about that. I'm asking you why, before this, did Mr. Miranda send you an email asking you on July 19, 2002, asking you and another Bush official why the Leahy people were looking into financial ties between two special interest groups and Priscilla Owen, a particular controversial nominee to the Fifth Circuit? You would handle that Owen nomination. As you know, as a judge, she had received a lot of contributions.
Well,
did Mr. Miranda send you an email asking you why the Leahy people were looking into her financial ties?
Is that what this email is?
I'm just asking you.
Well, can I take a minute to read it?
Of course.
Okay.
It was 4 days before her hearing on July 23rd.
Did I send any of the emails on this chain? I don't think so. I think I'm CC'd. In any event, if he said, why are the Leahy people looking into this? From Manny Miranda. I don't really have a specific recollection of any of this, Senator, but it would not have been at all unusual for, and this happens all the time, I think, which is the Leahy people are looking into this and the Hatch people are looking into that. I think.
You say all the time, 2 days before the hearing, he told you that the Democrats were passing around a related 60 Minutes story, and he said his intelligence, suggests that Leahy will focus on all things money. Well, that appears to come from a stolen email to me, stolen by the Republican staff member, sent to me the night before, and then given to you the next morning. Mm-hmm. Were you aware that you were getting from Mr. Miranda stolen emails?
Not at all, Senator. It was part of what appeared to be standard discussion about. It's common, Senator, for at the White House, it'd be common to hear from our Leg Affairs team. This is, in fact, in this process, it's common to hear. This is what Senator X is interested in. This is what Senator Y is going to focus on.
Was it common to have copies of a private email sent to a particular senator?
Copies of a private email sent to a particular senator?
Yes. Wouldn't that jump out at you?
What,
For example,
what are you referring to?
Well, Mr. Miranda is telling you about emails sent to me the night before. There'd be no way that he would even have that unless he stole it. Did that raise any question in your mind?
Did he refer to that email in this?
Yes.
And where is that, Senator?
I'll let you read it.
Well, I'm not seeing where you're. I'm not seeing what you're referring to.
Yeah, it's not here.
Okay. Well, let me take you one that you do have, because you do have this information from Mr. Miranda, and the very limited amount of material that the Republicans are allowing us to see of your information about you, that at least did come through. But in January 2003, let me go to something very specific. Mr. Miranda forwarded you a letter from me and other Judiciary Democrats to then Majority Leader Tom Daschle. The letter was clearly a draft. It had typos and it wasn't signed. Somebody eventually, we never put it out, but somebody eventually leaked its existence to Fox News. I'm not sure who. I could guess. It was a private letter the time I was shocked to learn it existed, it had been leaked. But here's the thing. You had the full text of my letter in your inbox before anything had been said about it publicly. Did you find it at all unusual to receive a draft letter from Democratic senators to each other before any mention of it was made public?
Well, the only thing I said on the email exchange, if I'm looking at it correctly, Senator, was who signed this, which would imply that I thought it was a signed letter.
It was sent to you. Were you surprised to get it? I mean, it's obviously a draft. It's got typos and everything else. Were you surprised the draft letter circulated among Democrats ended up in your inbox?
But
from Mr. Miranda.
I think the premise of your question is not accurately describing my apparent recollection or understanding of the time, because I wouldn't have said who signed this if I thought it was a draft. And my email says who signed this.
So you didn't realize what you had was a stolen letter signed by me, that you had a letter that had not been sent to anybody, had not been made public?
Well, all I see that I said was who signed this. That's all I see.
Oh, well, let me ask you some more, because so much of this came from Mr. Miranda, who was a Republican staffer who was, as we now know, stealing things. Did he ever ask to meet privately with you at an off-site location somewhere other than the White House or Capitol Hill?
I think sometimes, Senator, that the meetings with Senate staffers and White House and Justice
I'm
Department.
just asking about one particular one, Mr. Miranda.
Yes, sometimes, usually it would be either at the White House or the Senate, but I think sometimes we'd meet, or DOJ, but sometimes it could be somewhere else.
Well, did he ask to meet with you privately so he could give you information about Senator Biden and Senator Feinstein?
I'm not remembering anything specific, but that's certainly possible. And again, Senator, I just want to be clear here, because it's very common when you're in judicial selection process to determine what are all the senators interested in for an upcoming nominee or an upcoming hearing. That is the coin of the realm. Senator X is interested in focusing on administrative law. Senator Y is going to ask about environmental law. Senator is concerned about your past work for this client. And that's a very common kind of discussion.
Did he ever ask to have you meet him, not at the White House, not at the Capitol, but at his home?
I don't remember that.
Okay. Did he ever ask to meet you outside of the White House or the Capitol?
I can't rule that out, but again, that wouldn't have been typical.
Did he ever hand you material separately from what would be emailed back and forth?
Not remembering if you're referring to something in particular, I can answer that. But
Okay, well, let me ask you this. Did you ever receive information via Mr. Miranda, information marked confidential that informed you what my staff was sharing with other Democrats?
I don't know the answer to that, Senator, but again, it's not always the case, at least my understanding, that the people on, for example, your staff and Senator Hatch's staff were necessarily working at odds. It seemed like a lot of times the staff was cooperating at times, not at other times, obviously, but at times about judicial nominations. And so it wouldn't have raised anything in particular in my mind if we learned, Senator Leahy's concerned about this.
Did my staff ever send you confidential material from Senator Hatch that was stolen from his emails?
Well, not the last part, but I certainly did talk to your staff when we were working on the airline bill on the September 20, 2001 airline bill. I did remember being here all night one night with your staff, and I'm sure we did talk that night about what other senators thought. And that was the airline bill where, I think you recall, Speaker Hastert was involved, and we were up there with the OMB team. So in that, I worked hard with your staff on that. It just struck me as not uncommon at all to be talking with our ledge team about what senators on both sides think. It didn't strike me that it was always armed camps.
But no, and oftentimes it was not. But here you're getting obviously very private Democratic emails. You weren't concerned how Mr. Miranda got them?
Well, I guess I'm not sure about your premise.
Were you at all concerned about where Mr. Miranda got some of the material he was showing you?
I don't recall that, but on the premise of your last question, I want to step back to that. Not sure I agree with the premise.
I just say, if you're getting something that's marked confidential, wouldn't you assume that's not something being shared back and forth?
Unless it was shared. I mean, this is the thing. If a staffer said, "Here's what we're sending to," you all should be aware of this because we're going to make we're going to be really opposed to this judicial nominee. So just to be clear, it seemed to me sometimes there were judicial nominees you were very opposed to, sometimes you were supportive of, sometimes in between, and there would be messages passed back and forth and sharing of information. Very cooperative, as I recall.
Well,
you were transparent. In other words, when you had problems with nominees, I recall transparency, and when you were supportive. You were at the May 9th, 2001 event at the White House, I recall, where the president announced his first 11 Court of Appeals nominees, and you were supportive of many of them.
Well, as you know, but as a fact, I voted for a lot of Republican nominees.
Yes.
Both to the Supreme Court, the Courts of Appeals, and the District Court.
Yes.
But when I've opposed one, like with Judge Owen, when I was raising some very questions about funding that she was getting from people that were before her court, that might have raised a red flag that I had some concerns about her. Now, when you worked at the White House, did anyone ever tell you they had a mole that provided them with secret information related to nominations?
I don't recall the reference to a mole, which sounds highly specific, but certainly it is common. Again, and the people behind you can probably refer to this, but it's common, I think, for everyone to talk to each other at times and share information. At least this was my experience. This is 20 years ago almost, where you would talk to people and the committee.
You never received an email from a Republican staff member with information claiming to come from spying on Democratic mole?
I'm not going to rule anything out, Senator. But if I did, I wouldn't have thought that anything. I wouldn't have thought that the literal meaning of that. But
wouldn't it surprise you that if you got an email saying you got that from somebody spying on Democrats?
Well, is there such an email, Senator? I don't know. I mean,
well, we'd have to ask the chairman what he has in his confidential material.
But here's the if you're referring to something particular, here's what I know.
Hey, just stop a minute here. Reference twice in your 30 minutes, and don't take this off of his time. You made reference. You're talking about the period of time that he was White House counsel.
Yep.
That material's available to everybody.
So that bit of the material about him that's marked committee confidential is now public and available? Is that what you're saying? If that's what the chairman say, we got a whole new series of questions.
No, not if it's committee confidential. But you have access to it.
Not so
but,
that
but
I
don't
can
forget, 80% of the material we've gotten from the library is on the website of the Judiciary Committee, so the public has access to it.
No,
proceed.
I want Judge Kavanaugh to have access so that we can ask him these questions under oath and he can see them. So I would ask and we'll have another round, but I would ask the chairman if he might look at some of these that are marked committee confidential, which limits the ability of us to ask you specifically and hand you the specific emails. But I would state on what has been public.
Let me answer that for you. There's only one Democratic senator asked for access to that. Senator Klobuchar got it. If you're interested in it, you could have been asking ever since August the 25th, I believe.
We've been asking to have that those made public. I'm not as interested if I see this in a closed room where I can't talk about it. I want Judge Kavanaugh to see the emails which came from Mr. Miranda
give us a citation of the documents and we'll get them for you.
That testimony up there is true. 100%.
Can somebody read it? You can't see it. What?
Well, of course, it would be helpful if we allowed the National Archives time to complete their review.
But I just want to reassure you, Senator, because you're asking important questions. I want to reassure you that what you've got up on the board is 100% accurate.
Can somebody move it so we can see it here?
Well, I am concerned because there is evidence that Mr. Miranda provided you with materials that were stolen from me. And that would contradict your prior testimony. It's also clear from public emails, and I'm restrained from not going into the non-public ones, that you had reason to believe materials were obtained inappropriately at the time. Now, Mr. Chairman, there are at least 6 documents that you consider committee confidential that are directly related to this. Just like the 3 documents I shared, they're already public. These other 6 contain no personal information, no presidential records, Act restricted material. There is simply no reason they can't be made public. I hope they will be before this next round. It is difficult when to ask a question, I have to ask the Republicans, will you allow me to ask the question? I certainly never did that when I was chairman. Now, I'd asked you in 2006 whether you'd seen any documents relating to President Bush's NSA warrantless wiretapping program, or whether you'd heard anything about it. You answered you learned about it with the rest of us in December 2005 when the New York Times reported. Now, I know it's been 12 years, so here's a video of your sworn testimony. Should be on the TV screens. The documents relating to the president's NSA warrantless wiretapping program?
Senator, I learned of that program when there was a New York Times story, or the reports of that program when there was a New York Times story that came over the wire, I think on a Thursday night in mid-December of last year.
You had not seen anything, or had you heard anything about it prior to the New York Times article?
No.
Nothing at all?
Nothing at all.
Mr. Chairman, can I?
Can I again, don't take this time away from him. Now, as far as I know, in 15 hearings, so I'm going to read something in just a minute, but preface it with this. As far as I know, in 15 hearings that I've been involved in of Supreme Court justices, there's never been such a video shown. So since this is precedential, I want to read this. The use of a video at a confirmation is highly irregular, but I see no reason why my colleagues can't use a video that was provided by the nominee himself in response to the Senate questionnaire. I've been assured that the video is from Judge Kavanaugh's submission to the committee. Based on this assurance, we've allowed this video to be shown. But I want to emphasize that I expect that video to be used fairly. The video clip should not be presented in a way that deprives it of relevant context. This is consistent with requirements in federal court. That's why I will insist that Judge Kavanaugh have the opportunity, before he answers this question, to request if any additional video be played if it provided appropriate context. So, Judge Kavanaugh, I would ask you, do you believe that more context is needed to be able to address the question?
Well, I don't think I've heard the question yet, but I'll let you know when I hear the question.
Let me ask you this. I'll repeat the question I asked before. You said you heard about this with the rest of us in December 2005. You said on there that you had no knowledge of anything related to this until the New York Times article. Now we have a declassified Inspector General report that on September 17, which was before several months before the New York Times article, John Yoo issued a memo on surveillance of the White House that helped form the legal underpinnings of the NSA warrantless wiretapping program. When you were in the White House in 2001, did you ever work with John Yoo on the constitutional implications of a warrantless surveillance program?
We're talking about a lot of different things, Senator, here.
Warrantless surveillance program.
And that's talking about a lot of different things. So what you were asking about right there was the specific, what President Bush called the terror surveillance program. That was his name for it.
Which is a warrantless surveillance program.
Along with many others. And you were asking me about the terrorist surveillance program, TSP, I think he called it. That story was broken. That testimony is 100% accurate. That story was broken in the New York Times. I had not been read into that program. And when it came in the New York Times, I actually still remember my exact reaction when I read that story. And then the president that Saturday, I believe, did a live radio address to explain to the country what that program was about. There was a huge controversy. And so everyone was then working on getting the speech together. And you asked me if I'd learned about it before then. I said no, and that's accurate.
Okay. When you were in the White House, did you ever work with John Yoo on the constitutional implications of any warrantless surveillance program?
Well, I can't rule that. Right in the wake of September 11th, it was all hands on deck on all fronts, and then we were farming out assignments, but we were all involved. On September 12th, when we came in, let's just back up. On September 12th, when we came into the White House, it was, we have to work on everything. And so then over time, people figured out what issues they were going to work on. The airline bill that I was up here on September 20th when the President Bush spoke to Congress that night, as you recall. And then after that, we were in the meeting room together, you and I and others, working on the airline bill. But there were all sorts of other things going on. The Patriot Act was going on.
I know. I was involved with all of those. And
yes,
I know the discussions. But I want to know, did you ever raise questions about warrantless surveillance?
I can't rule anything out like that. There was so much going on in the wake of September 11th, Senator, as you recall, up here too, but in the White House in particular, and in the counsel's office in particular. We had 8 lawyers in there, 8 or 9, as I recall, and there were so many issues to consider for the president and for the legal team, and those issues, like I said, for President Bush, every day for the next 7 years was September 12th. 2001. And, for the legal team, there was a lot.
For a lot of us, it was.
Yes.
But Mr. Chairman, I sent a letter to you along with Senators Feinstein and Durbin on August 16th of this year, asking that we make documents related to this issue public. Without them being public, it's not fair to me and it's not fair to Judge Kavanaugh that I can't hand him the actual documents, which I think would refresh his memory. And I would ask again, you might look at that before my next term, can we make those public?
You tell us what documents you want, and I'll make them available to you, but I can't say that they can be made public. Just as I said last year during Justice Gorsuch's confirmation, I put a process in place that will allow my colleagues to obtain the public release of confidential documents for use during the hearing. All I asked was my colleagues to identify the documents they intended to use, and I would work to get the Department of Justice and former President Bush to agree to waive restrictions on the documents. Senator Feinstein secured the public release of 19 documents last year under this process, and Senator Klobuchar secured the release of 4 documents this year. If my colleagues truly believe that other committee confidential documents should have been made public, they never told me about them. So let us know what you want, and then you can go ahead and we'll get them for you.
I want the same thing that I requested on August 16th, because it's directly relevant to Judge Kavanaugh's testimony, directly relevant to the questions I've been asking here, directly relevant to his own emails with John Yoo. So before my next turn, we could take a look at that.
Okay. Well, we'll get them for you for your next turn tomorrow.
Now, you said everyone agrees the pardon power gives the president absolute, unfettered, unchecked power to pardon every violator of every federal law. Could a president issue a pardon in exchange for a bribe? Yes or no?
Senator, I think that question has been litigated before, and I don't want to comment about anything.
Well, let me ask you this:
the scope of the pardon. I don't want to scope about. There are a couple things involved in that question. One is what's the scope of what's the effect of the pardon, and the other question is can you be separately charged with the bribery crime, both the briber and the bribee. And those are two distinct questions. You'd want to keep those two questions separate in thinking about how the hypothetical.
Then in that, Mr. Chairman, I got interrupted an awful lot during my time. I just want to finish this question.
But I made sure that if the timer didn't treat, give him another minute.
Thank you. God bless you. I'll be forever thankful. President Trump claims he has an absolute right to pardon himself. Does he?
The question of self-pardons is something I have never analyzed. It's a question that I have not written about. It's a question, therefore, that's a hypothetical question that I can't begin to answer in this context as a sitting judge and as a nominee to the Supreme Court.
And the other half of that is the obvious one. Does the president have the ability to pardon somebody in exchange for a promise from that person they wouldn't testify against him?
Sarah, I'm not going to answer hypothetical questions of that sort. And there's a good reason for it. When judges don't, when we decide, we get briefs and arguments of the parties. We have a record. We have an appendix with all the information. We have amicus briefs, and then I never decide anything alone. I'm in a panel of 3, and if I'm confirmed to the Supreme Court, I'd be on a team of 9.
Thank you, Mr. Chairman. I hope for the sake of the country that remains a hypothetical question. Thank you.
And since I gave you an extra minute, I'm not going to let you reserve the 25 seconds.
I'm done.
Senator Graham.
Thank you very much. July the 21st, 1993. I certainly don't want you to have to lay out a test here in the abstract, which might determine what your vote or your test would be in a case you have yet to see that may well come before the Supreme Court. That was wise counsel by Senator Leahy in the Ginsburg confirmation. Very directly, did you ever knowingly participate in stealing anything from Senator Leahy or any other senator?
No.
Did you ever know that you were dealing with anything that was stolen property?
No.
As to the terrorist surveillance program, did you help create this program?
No.
Did you give legal advice about it?
No. We're referring to the same program I was talking about there. Yes.
The one that the article was about. So a bit of a kind of a run through here. You're probably going to get 55 votes. I don't know, 54 to 56 or 57. I don't know what the number will be. There are 11 undecided senators before the hearing. 3 of them are Republicans. I like your chances. 8 of them are Democrat. You're in play with about 5 or 6 of them. And I just want you and your family to know that in other times, someone like you would probably get 90 votes. I want your daughters to know that what happened yesterday is unique to the times that we live in. And I want to give you a chance to say some things to the people who have attended this hearing. I think there's a father of a Parkland student who was killed. I think there's a mother of a child who has got terrible health care problems, and there are many other people here with personal situations. What would you like to say to them, if anything, about your job as a Supreme Court Justice?
Well, Senator, I understand the real-world effects of our decisions. In my job as a judge for the last 12 years, I've gone out of my way in my opinions and at oral arguments, if you listen to oral arguments, to make clear to everyone before me that I understand the situation, the circumstances, the facts. For example, as I was saying to Senator Feinstein earlier in the Heller 2 case about the facts in D.C. And I want to reassure everyone that I base my decisions on the law, but I do so with an awareness of the facts and an awareness of the real-world consequences. And I've not lived in a bubble, and I understand how passionately people feel about particular issues, and I understand how personally people are affected by issues. And I understand the difficulties that people have in America. I understand, for example, to start, I understand the situation of homeless people because I see them on a regular basis when I'm serving meals.
So tell me about that. What interaction do you have with homeless people?
Senator, I regularly serve meals at Catholic Charities at 10th and G with Father John Ensler, who's the head of Catholic Charities D.C., and I've known since I was 9 years old when I was an altar boy. He was at Little Flower Parish. And what you learn when you're at, I said I'm a Matthew 25, try to follow the lesson of serving the least fortunate among us. You know, when I was hungry, you gave me food, thirsty, you gave me drink, stranger, and you welcomed me, naked, and you clothed me, sick, and you cared for me, in prison, and you visited me. Six groups that, that's not exclusive, but that's a good place to start with your charitable works in your private time.
So describe the difference between Brett Kavanaugh, the man, and Brett Kavanaugh, the judge.
Well, as a man, I'm trying to do what I can in community service as a dad, as a coach, as a volunteer, as a teacher, as a husband, and serving meals to the homeless. The one thing, Senator, you know, we're all God's children. We're all equal. People have gotten there because maybe they have a mental illness. Maybe they had a terrible family situation. Maybe they didn't have anyone to care for. Maybe they lost a job and had no family. But every person you serve a meal to is just as good as me or better, frankly, because they've what they've had to go through on a daily basis just to get a meal. And you talk to them. That's the other thing. When you're walking by the street, you see people, and I understand, I'm sure I've done this. I don't want to sound better than someone describing this, but you don't necessarily look and you don't say, how's it going?
Right.
But when you serve meals to them, and you talk to people who are homeless, and they are just as human and just as good a people as all of us. And we're all part of one community. And so I think about that. And, I don't want to sound like I can always do more and more and do better. I know I fall short, but Father John has been a big influence on that and thinking about others. So that's as a person. I try to do Washington Jesuit Academy. So I tutor up there. I'm now on the board of Washington Jesuit Academy. That's a little different situation. Okay, those are low-income boys from low-income families, tuition-free school, one of these 7:30 a.m. to 7 schools. And I started tutoring up there because I wanted to do some more tutoring and just be involved more. I mean, judging's important, but I wanted to be more directly involved in the community. And they had tutoring. You do all your homework there because it was a situation you don't want to go home and have anything else to do. You get 3 meals there and you do your homework there, and to help them do their homework. And you see these great kids, and they're in a structured environment, and you make an effect in their lives. And like I said yesterday, the teachers and coaches throughout America, they change lives. And for me to be able to participate, you can't change everything at once, but just changing one life, one meal one day at the shelter, or one kid that remembers something you said in a tutoring program. If we all did that more, and I fall short too, I know, and I want to do more on that front, but you can make a big difference in people's lives. I just bring that into the judging. I think I judge based on the law, but how does that affect me as a judge? I think first of all, just standing in the shoes of others. We could all be that homeless person. We could all be that kid who needs a more structured educational environment. And one of the things I was taught by my mom, but also I remember Chris Abel, my 6th grade English teacher and religion teacher, and football coach and baseball coach. One of his, and he drove me to school. One of his, and he's now on the board of Washington Jesuit Academy with me. But one of his lessons in To Kill a Mockingbird was to stand in the shoes of others. And I still have the To Kill a Mockingbird that we used in 6th grade. It's in my chambers. Still, the same copy.
Is it fair to say that your job as a judge is to not so much stand in the shoes of somebody you're sympathetic to, but stand in the shoes of the law?
You're in the shoes of the law, but with awareness of the impacts of your decisions.
Right.
And that's the critical distinction. You can't be unaware. When you write an opinion, how's it going to affect people?
Right.
And understand, try to explain. I think, it's explaining is such an important feature. And then when people come into the courtroom and how you treat litigants. So we're all familiar. We've all been in courtrooms where the judge is acting a little too full of being a judge. We've all been there. I try not to do that. I can't say I'm perfect, but I try to make sure the litigants understand that I get it, whether it's a criminal defendant case. We had a pro se case where a litigant comes in and argues pro se in our court, which rarely happens in our court where the pro se actually argues. And it was a guy who said he had been called the N-word by a supervisor. And he's arguing pro se, and the question's whether a single instance of the N-word constitutes racial harassment under the civil rights laws. And I wrote a separate opinion explaining, yes, a single instance of the N-word does constitute a racially hostile work environment. And I explained in doing that, I explained the history of racism in this country and how that word, no other word in the English language so powerfully or instantly calls to mind our country's long and brutal struggle against racism, I wrote in that opinion. And I cited To Kill a Mockingbird in that opinion, among other things. But what I wanted to make clear by bringing this example up is I understood his situation. I tried to understand what that would be like, and I decided the case based on the law, but I understood with the pro se litigant. The point being, I always try to be aware of the facts and circumstances.
Have you ever made a legal decision that personally was upsetting to you?
Well, I'm sure I have, and that's what Justice Kennedy talked about in Texas versus Johnson. That case, in case people didn't know what I was referring to on Texas versus Johnson, that's the flag burning case. And Justice Kennedy is in the majority with Justice Scalia and Justice Brennan, Justice Marshall, and says that a law against flag burning is unconstitutional under the First Amendment. And that obviously tore Justice Kennedy, really bothered him because he's such a patriot. But he still ruled the way he did because he read the First Amendment to compel that result. And that's why he wrote that great concurrence in that case. And that concurrence is such a great model for judging and a great model of independence and a great model, to your point, Senator Graham, of we follow the law, but we're aware. And you're a better judge if you're aware.
Well, I would just want to say this to my colleagues. Everything he said, I think, has been verified by the people who know him the best. I can't say I've read 307 of your opinions. I can tell you without hesitation I have not. I did not read Sotomayor opinions or Kagan's writings. But what I chose to do was look at the people who knew them the best. And I think Bob Bennett, who defended President Clinton during impeachment, I know him very well, said that Brett is a judge's judge, someone doing his absolute best to follow the law rather than his policy preferences. Brett is an all-star in both his professional and his personal life. I've yet to find anybody that I find credible, or really anybody at all, that would suggest that you were unfair to litigants. I've yet to find a colleague that thought you were a politician and a rogue. But you are a Republican. Is that true?
I registered.
Okay.
Yeah.
The only reason I'm glad to hear you say that, it makes a lot of sense, given who you worked for. And,
I haven't. Well, I'll let you finish your question.
Well, you worked for a lot of Republicans, like
yes.
the president, who was a Republican. So
President Bush,
yeah,
worked for, yes.
Yeah. So that's all fine.
What is at stake?
So, I remember.
Where in this country is at stake?
I remember.
Workers' rights is what at stake.
I'll tell you what I remember when she leaves. So, I asked Elena Kagan about a statement that Greg Craig made. Do you know Greg Craig by any chance?
I've met him. I haven't seen him in many years, but yes.
He was the one of the defenders of President Clinton during the impeachment hearing. And somewhere in here, I've got Greg Craig's statement about Kagan.
This is the Graham-Kagan exchange.
No, I'm looking for Greg Craig's statement. Here we go. Here's what Kagan was a progressive in the mold of Obama himself. Elena Kagan is clearly a legal progressive and comes from the progressive side of the spectrum, according to Ronald Klein. The first was Greg Craig. And I had an exchange with Justice Kagan when she was the nominee. I'm not trying to trick you. I don't have anything on Greg. He said on May 16th that you're largely progressive in the mold of Obama himself. Do you agree with that, Ms. Kagan? Senator Graham, you know, in terms of my political views, I've been a Democrat all my life. I worked for 2 Democrat presidents, and that is what my political views are. And I asked, would you consider your political views progressive? Ms. Kagan, my political views are generally progressive, which is true. I really appreciate what she said because I expect President Obama to go to someone like Elena Kagan, who is progressive, shares his general view of judging, and who happened to be highly qualified. Sotomayor. President Obama nominated Sotomayor because he wanted someone whose philosophy of judging was his, which is applied to the law and constitutional principles, was be ready to adopt them to a modern context. So President Obama nominated Sotomayor because he wanted someone whose philosophy of judging was his. I expect that to happen. If Donald Trump is president in 2020, he'll be our next president. If it's somebody else, I expect that to happen. To my colleagues on the other side, what do you really expect? You should celebrate, even though you don't vote for him, and I don't know why you wouldn't, the quality of the man chosen by President Obama. Elena Kagan and Sotomayor came from the progressive wing of the judging world and of legal thought. They're absolutely highly qualified, good, decent people. And they got, let's see if I can find the vote totals. Ms. Kagan got 63 votes and Sonia Sotomayor got 68. It's going to bother me that you don't get those numbers, but what bothers me is they should have gotten 90. They should have gotten 95. Anthony Kennedy got 97. Anthony Scalia got 98. Ruth Bader Ginsburg got 96. So what's happened? Between then and now, advise and consent has taken on a different meaning. It used to be the understanding of this body that elections have consequences, and you would expect the president who won the election to pick somebody of their philosophy. I promise you that when Strom Thurmond voted for Ruth Bader Ginsburg, he did not agree with her legal philosophy. And I doubt if Senator Leahy agreed with Justice Scalia. Senator Leahy has voted for a lot of Republicans. I have voted for everyone presented since I have been here because I find them to be highly qualified, coming from backgrounds I would expect the president in question to choose from. So as to your qualifications, how long have you been a judge?
I've been a judge for 12 years.
How many opinions have you written?
I have written over 300 opinions.
Okay. Do you think there's a lot we can learn from those opinions if we spend time looking at them?
Yes, I am very proud of my opinions, and as I mentioned, I tell people don't just read about the opinions, read the opinions. I'm very proud of them.
You were nominated by President Trump on July the 9th, my birthday, which I thought was a pretty good birthday present for somebody who thinks like I do. And I think Don may have something to do with that, at 9 o'clock. By 9:23, Chuck Schumer says, I will oppose Judge Kavanaugh. By 9:25, Senator Harris, Trump Supreme Court Justice nominee Judge Kavanaugh represents a direct and fundamental threat to the rights and health care of hundreds of millions of Americans. I will oppose his nomination. Elizabeth Warren at 9:55. President Brett Kavanaugh's record as judge and lawyer is clear, hostile to health care for millions, opposed to the CFPB, corporate accountability, thinks President Trump is above the law, on and on and on. Nancy Pelosi at 10:11, Bernie Sanders at 10:18. If Brett Kavanaugh is confirmed to the Supreme Court, it will have profoundly negative effect on workers' rights, women's rights, and voting rights for the decades to come. All I can say, within an hour and 18 minutes of your nomination, you became the biggest threat to democracy in the eyes of some of the most partisan people in the country who would hold Kagan and Sotomayor up as highly qualified and would challenge any Republican dare vote against them. You live in unusual times, as I do. You should get more than 90 votes, but you won't. And I am sorry it has gotten to where it has. It's got nothing to do about you. If you don't mind, and you don't have to, what did you tell your children yesterday about the hearing?
They did as they, I'll tell them what they told me. I think they gave me a big hug and said, good job, Daddy. And Margaret, before she went to bed, made a special trip down and said, give me a special hug.
I just wish if we could have a hearing where the nominees' kids could show up. Is that asking too much? So what kind of country have we become? None of this happened just a couple of years ago. It's getting worse and worse and worse. and all of us have an obligation to try to correct it where we can. Roe v. Wade. Are you familiar with the case?
I am, Senator.
Can you, in 30 seconds, give me the general holding of Roe v. Wade?
As elaborated upon in Planned Parenthood versus Casey, a woman has a constitutional right, as interpreted by the Supreme Court on the Constitution, to obtain an abortion up to the point of viability, subject to reasonable regulations by the state, so long as those reasonable regulations do not constitute an undue burden on the woman's right.
Okay, as to how the system works, can you sit down with you and 4 other judges and overrule Roe v. Wade just because you want to?
Senator, Roe v. Wade's an important precedent of the Supreme Court, been reaffirmed.
But don't you have to have a case you just can't,
yeah.
Hey, what are you doing for lunch? Let's overrule Roe v. Wade. It doesn't work that way, right?
I see what you're asking, Senator. Right. There's the way cases come up to us in that context or in other contexts would be a law's passed.
Can I give you an example? Because I can do this quicker.
Yes.
So some state somewhere or some town somewhere passes a law that runs into the face of Roe. Somebody will object. They'll go to lower courts, and eventually it might come up to the Supreme Court challenging the foundations of Roe v. Wade. It would take some legislative enactment for that to happen. Is that correct?
That's correct.
If there was such a action by a state or a local government challenging Roe and it came before the Supreme Court, would you listen to both sides?
I listen to both sides in every case, Senator. I have for 12 years, yes.
When it comes to overruling a longstanding precedent of the court, is there a formula that you use? Analysis.
First of all, you start with the notion of precedent. And as I've said to Senator Feinstein, in this context, this is a precedent that's been reaffirmed many times over 45 years, including in Planned Parenthood versus Casey, where they specifically considered whether to overrule and reaffirmed and applied all the stare decisis factors. So that, importantly, became precedent on precedent in this context. But you look at there are factors you look at whenever you're considering any precedent.
So there's a process in place that the court has followed for a very long time. Is that correct?
That is correct, Senator.
Citizens United.
Yes.
If somebody said Citizens United has been harmful to the country and made a record that the effects of Citizens United has empowered about 20 or 30 people in the country to run all the elections, and some state or locality somewhere passed a ban on soft money, and it got to the court, would you at least listen to the argument that Citizens United needs to be revisited?
Of course, I listen to all arguments. You have an open mind. You get the briefs and arguments, and some arguments are better than others. Precedent's critically important. It's a foundation of our system, but you listen to all arguments.
Okay. Where were you on September 11th, 2001?
I was initially I was in my then office in the EOB, and then after the first, as I recall, after the first building was hit, I was in the council's office on the second floor of the West Wing for the next few minutes. Then we were all told to go down to the bottom of the West Wing, and then we were all evacuated. And I think the thought was Flight 93 might have been heading for the White House. It might have been heading here. And Secret Service, we were being hustled out, and then kind of panicked, started screaming at us, sprint, run, and we sprinted out. My wife was a few steps ahead of me. She was President Bush's personal aide at the time, and we sprinted out. She was wearing a black and white check shirt, I remember. And we sprinted out the front gate kind of into Lafayette Park, and no iPhones or anything like that. BlackBerries at that point in time, we didn't have that, and our cell phones didn't work, so we were all just kind of out there. And then I remember somehow ending up seeing on TV down more on Connecticut Avenue, there were TVs out. Mayflower Hotel. I remember I was with Sarah Taylor, who worked at the White House, and we were watching as the standing with her when the buildings fell.
So when somebody says post 9/11 that we've been at war, and it's called the war on terrorism, do you generally agree with that concept?
I do, Senator, because Congress passed the authorization for use of military force, which is still in effect, and that was passed, of course, on September 14th, 2001, 3 days later.
Let's talk about the law in war. Is there a body of law called the law of armed conflict?
There is such a body, Senator.
Is there a body of law that's called basic criminal law?
Yes, Senator.
Are there differences between those two bodies of law?
Yes, Senator.
From an American citizen's point of view, do your constitutional rights follow you? If you're in Paris, does the Fourth Amendment protect you as an American from your own government?
From your own government, yes.
Okay. So if you're in Afghanistan, do your constitutional rights protect you against your own government?
If you're an American in Afghanistan, you have constitutional rights as against the U.S. government.
Is there a long-standing...
That's long-settled law.
Isn't there also a long-settled law that it goes back to the Eisentrager case? I can't remember the name of it.
Yeah, Johnson versus Eisentrager.
Right. That American citizens who collaborate with the enemy have considered enemy combatants.
They can be. They can be. They're sometimes criminally prosecuted, sometimes treated in the military.
Well, let's talk about can be. I think
under Supreme Court precedent.
Right. There's a Supreme Court decision that said that American citizens who collaborated with Nazi saboteurs were tried by the military. Is that correct?
That is correct.
I think a couple of them were executed.
Yeah.
So if anybody doubts, there's a long-standing history in this country that your constitutional rights follow you wherever you go, but you don't have a constitutional right to turn on your own government and collaborate with the enemy of the nation. You'll be treated differently. What's the name of the case, if you can recall, that reaffirmed the concept that you could hold one of our own as an enemy combatant if they were engaged in terrorist activities in Afghanistan? Are you familiar with that case?
Yeah, Hamdi.
Okay. So the bottom line is, I want every American citizen to know you have constitutional rights, but you do not have a constitutional right to collaborate with the enemy. There's a body of law well developed long before 9/11 that understood the difference between basic criminal law and the law of armed conflict. Do you understand those differences?
I do understand that there are different bodies of law, of course, Senator.
Okay. If you're confirmed, and I believe you will be, what is your hope when all of this is said and done and your time is up? How would you like to be remembered?
A good dad, good judge.
Good husband.
I think he's getting there.
Good husband.
Thanks, Diane. You helped him a lot. It's going to be better for you tonight.
Good. I owe you. Good son, I'll quickly add. Good friend. I think about the pillars of my life are being a judge, of course, being a teacher. I've done that, and either way this ends up, I'm going to continue teaching. Coaching, as I mentioned, huge part of my life. Try to continue that. Senator Kennedy advised me when we met, make sure you keep coaching, even if you get. I'm going to follow that. Volunteering, and being a dad and a son, and a husband, and being a friend. I talked about my friends yesterday. I didn't really expect. I got a little choked up talking about my friends. But.
That was well said. You got to tighten it up because I just ran out of time.
Okay. Thank you, Senator. I can go on, as you know, but I'll stop there.
Thank you.
We're about ready to break for lunch and a vote that we have, and it'll be 30 minutes. But before I do that, I have letters that Senator Feinstein asked me to put in the record from 70 letters from people in opposition to your nomination. And then we also have letters in support of Judge Kavanaugh from hundreds of men and women across the country holding diverse political views. They strongly support his confirmation without objection. Those will also be entered in the record. And then I wanted to explain the exchange that I had with Senator Leahy, that just so people don't think that that's something that I did on my own. We had previously sent out a letter, and only Senator Klobuchar up to that point had taken advantage of the letter to be able to ask for documents that were committee confidential so that they could use them at the hearing. And the only thing I've done for Senator Leahy that wasn't already in that letter was to remind people that we did the same thing for the Gorsuch nomination to the Supreme Court, and it's a policy that Senator Leahy, when he was chairman of the committee, followed. And so the only courtesy was extended to Senator Leahy the fact that he didn't make the request by the timeline that was in the letter, which I think was August 25th. We're going to adjourn 30 minutes for lunch break, and I think that we'll be back here exactly in 30 minutes. If not, Judge Kavanaugh, we will let your staff know if it's going to be a little later, because you never know what happens in the United States Senate when you have a vote.